Welcome to our webinar on shared parental leave, dealing with tricky issues. My name's Lisa Kelly and I'm a solicitor in the employment team at Muckle, and I'm joined today by my colleague Frances Cameron, who's an associate solicitor also in the employment team at Muckle. As some of you may already be aware, we have prepared a webinar covering the basics and how shared parental leave works in practice. The focus of this webinar is to address difficult areas, and we have had a number of queries from clients and we've tried to factor these into the presentation. So thank you very much for any of you who did email us with queries. A second point is that at the point in time when we did the original webinar, the regulations were still in draft. However, the final regulations have now been published and came into force on the 1st of December 2014. We're very pleased to confirm that there were no changes.
Great, thanks Lisa. So the first question that we've had from a business is, do we need to implement a shared parental leave policy?
That's a great question, Fran, thank you. I think the short answer is yes, we would recommend this. If nothing else, it helps to set out the expectations and the notification requirements to give employees guidance. In addition, from an employer's perspective, when you're considering drafting your shared parental leave policy, it's important to think about how are you going to make that marry up with your other family-friendly policies. So what are you going to offer eligible employees? For example, if you have an enhanced maternity policy, are you going to import any of the enhanced benefits into your shared parental leave policy? I think it's worth saying at this point that it's really important to be careful with your drafting, because you don't want to end up with a situation where an employee is entitled to both enhanced maternity benefits and then enhanced shared parental leave benefits. Okay, so on to our second question. Fran, does it matter that our employee's partner is self-employed?
Thanks Lisa. No, it doesn't, and we did cover this briefly on the initial webinar, but it was in the flow chart that we looked at. Essentially, if the mother or partner has been an employee or self-employed in the last 26 weeks of the 66 weeks prior to the child's birth or the adoption, and had an average weekly earnings of £30 or more over 13 weeks, then the employee is entitled to take shared parental leave. So it doesn't matter that the mother might be self-employed rather than an employee. And the only thing I should mention though is that the partner must have curtailed their maternity allowance. So this means either that they've stopped taking their maternity allowance or they've given notice that they will have a shorter entitlement to maternity allowance as a result of their partner taking shared parental leave.
Thanks, Fran. So does a man's shared parental leave entitlement reduce if they've taken paternity leave?
Again, the answer is no, it doesn't, which is perhaps a little bit surprising, because the compulsory maternity leave, which is the 2 weeks immediately after a child's birth that a mum has to take for health and safety reasons during her recovery, is deducted from the full 52 weeks that they're entitled to. So actually it's only 50 weeks that the two partners can share between themselves. But a man's entitlement to their ordinary paternity leave, which again is 2 weeks, does not get deducted from the amount of shared parental leave that they can share. So a man could take 2 weeks paternity leave as normal and then subsequently take, say, 25 weeks shared parental leave.
A question that we have been asked quite a few times now is, how do we know how much shared parental leave our employee is entitled to?
Yeah, this is going to be quite a tricky issue actually, and there's no easy answer to it. A large proportion of this is going to come down to trusting your employee. An employee must give notice of entitlement to be able to get shared parental leave, and in that notice of entitlement they have to declare the expected week of childbirth and the amount of shared parental leave that will be remaining to be shared between the two partners. So essentially they've got to give a declaration of how much maternity leave their partner has taken if it was a woman, for example. Then you are entitled to get the details of the partner's employer. So you could write to them and ask for more information, but for data protection reasons, I could see why that employer might not actually provide you with the information that you need. So ultimately, it's going to come down to trusting the employee who has given the declaration. And of course, if there is any suggestion that there's been any dishonesty, then that would be a misconduct issue. So Lisa, I'm probably going to ask you the most difficult question of all here, that has come from a number of businesses, as you can expect. We currently pay enhanced maternity pay. Do we need to also now pay enhanced shared parental leave pay?
Hi, thanks, Fran. That's a really good question. I have to be honest and say that since shared parental leave was announced, there's been much debate about this and whether importing enhanced maternity pay into the shared parental leave regime would amount to sex discrimination where there's not the same enhancement for the mother's partner. We consider that a direct sex discrimination claim is unlikely to succeed, as a claimant would have to point to a comparator of the opposite sex to show that there's been less favourable treatment because of sex. Now, in our view, the correct comparator for a man on shared parental leave is not a mother on shared parental leave benefiting from enhanced maternity pay imported into the shared parental leave, but the correct comparator would be somebody of the opposite sex in the same situation as him. So, for example, the partner of the mother. So a same-sex partner of a mother would not get enhanced shared parental leave pay either. So the difference in treatment, therefore, is not because of sex. However, we do think that the bigger risk in importing enhanced maternity pay into the shared parental leave regime, but not enhancing shared parental leave pay for others, is an indirect sex discrimination claim from a man. I think at this point it's worth briefly explaining what a claimant would need to establish in order to succeed with an indirect sex discrimination claim. So firstly, there must be a provision, criterion or practice, so a PCP, which applies to everyone. So for example, an enhanced maternity policy. The claimant must have a protected characteristic, so sex in this case, i.e. being a man as opposed to being a woman. The PCP must put people with the protected characteristic, so men, at a particular disadvantage compared to others who don't have that characteristic. So effectively we're comparing men with women and whether one group is placed at a particular disadvantage. It must put the claimant at that disadvantage. So if all of those limbs are established, then the employer would need to show that it had a legitimate aim in having the PCP, i.e. in having an enhanced maternity policy, and that it was proportionate. So to put that into context, I think it's worth referring to a recent case, and that's the case of Shutter and Ford Motor Company Limited, which concerned a sex discrimination claim brought by a man who took additional paternity leave. It's only a first instance decision, but it does give some guidance in this area. So the particular facts of that case were that Mr. Shutter took a period of additional paternity leave. This was paid at the statutory rate, whereas Ford paid enhanced maternity pay of 100% of basic pay for 52 weeks. So Mr. Shutter claimed that the failure to pay him his full basic pay during his additional paternity leave was sex discrimination. Now, his direct sex discrimination claim failed for the reasons that we've already explained. The tribunal basically felt that a woman on maternity leave was not the appropriate comparator. The correct comparator was a woman in the same position as Mr. Shutter, such as a same-sex partner. The more interesting aspect of the judgment is with regards to the indirect sex discrimination claim. Here, Mr. Shutter argued that paying women after the 20th week of maternity leave, which is the point at which additional paternity leave can be taken by the father or the partner, was a PCP that placed men and himself at a disadvantage. It's not really clear why from the judgment, but Ford actually conceded this point. So therefore, the focus of the case was whether the policy, i.e. having an enhanced maternity policy with enhanced pay, had a legitimate aim and whether that was proportionate. So Ford said that its legitimate aim was that its workforce was male-dominated. So the policy was introduced to recruit and retain female employees. Ford was actually able to show lots of statistics to show that there was a significant amount of men compared to women in its workforce. With regards to proportionality, Ford relied on a number of factors, such as the cost and disruption if large numbers of men took additional paternity leave, which couldn't be covered by its existing workforce, an unwillingness to reduce its existing maternity provision due to the impact that it would have on its legitimate aim of recruiting and retaining more women, and also the adverse publicity that withdrawing that benefit would have. And it also argued that additional paternity leave was for a different purpose to maternity leave. So, for example, maternity leave has got an element of health and safety aspect, as Franz touched on earlier. The tribunal found in Ford's favour. The tribunal considered that Ford had a legitimate aim and that the PCP was applied proportionately, despite the fact that it completely excluded men on additional paternity leave from enhanced pay. Clearly, the outcome of this case is positive for employers, but I feel that I must issue a health warning because the decision was heavily based on the facts and, in particular, the fact that Ford's workforce was heavily male-dominated. Therefore, I feel that the case doesn't have universal application, and so, unfortunately, there is no one-size-fits-all answer to this particular question. So given the indirect sex discrimination risk in enhancing shared parental leave pay for mothers but not for partners, before making a decision, we would urge employers to consider, firstly, whether the policy is likely to put men at a disadvantage. With shared parental leave compared to additional paternity leave, this might not necessarily be the case because actually both men and women can take shared parental leave, and in order for a lady to go on to shared parental leave, she has to curtail her maternity. So generally it might not be quite as stark as with additional paternity leave. Secondly, we would urge employers to think about what is the aim behind any enhanced pay policy. So when an enhanced maternity policy was introduced, what was the aim and ethos behind that? And finally, have a think about what proportionality arguments you as an employer would be able to run. Ironically, in our view, the safest thing to do in these circumstances, if you don't want to pay enhanced shared parental leave pay to all eligible employees, is not to import enhanced maternity pay into the shared parental leave regime. In that case, men and women would both be treated the same, so you're not exposing yourself to any discriminatory risks. Although the downside of this, of course, is that it may well disincentivize mothers from taking shared parental leave. However, the regulations don't include any anti-avoidance provisions, so we can't see, there's no clear legal challenge for doing that.
Thanks, Lisa. That was the tricky one. Just to follow on from that one, though, if we don't enhance shared parental leave pay, how would this impact on an employee who would benefit from enhanced maternity pay that wishes to take shared parental leave?
Well, it's slightly harsh perhaps, but as maternity leave must be curtailed, the employee would then move on to the shared parental leave regime. So if enhancements aren't transposed, then she'd lose them. So therefore, it comes back to, I think it is important to have policies so that employees can see what the different leaves are and what they entail, so they can assess what is on offer and can plan their leave accordingly. So back over to you, Fran. What payments will the it's
It's dependent on what policies obviously the employer has in place, as we've just been discussing, but assuming there's no enhanced shared parental leave entitlements, then it's up to 39 weeks statutory shared parental leave pay between the two partners, and because the mother will have to have the first 2 weeks off because of compulsory maternity leave, it's actually the 37 weeks that would be shared between them. They're not entitled between them to get more than you currently get under statute. Then on top of that, of course, there may be policies and procedures that entitle one partner or the other to an enhancement. And this is why it's going to be important for a couple in future, as you've already hinted, to get hold of their policies and at home read through them together to work out financially what is the best position for us. And you might find that there's not a huge uptake on shared parental leave if in fact it's better for them, for the mother to go off, as they often do at the moment, and take the full 1 year and benefit only under their policy. But for example, if the female doesn't get any enhancements under their policy and the man does, say if they've imported some enhanced pay into the shared parental leave policy, then it may be that you find more men taking the shared parental leave because they have a more enhanced policy than their partner. So I hope that was useful and dealt with some of the tricky issues that have started to come out of shared parental leave. If you have any more questions, please do feel free to email us. We're very conscious of the fact that more and more questions will come out of this new regime as we get closer to it. Our contact details are on the slide in front of you. Please do feel free to email either one of us. And in addition, I've just put up on the slide in front of you the different forums that we have here at Muckle. We've got a LinkedIn forum that you can discuss matters with us. We also have e-news that's regularly published on the website. And also we're on Twitter if you'd like to follow us. The address is on the screen now. Thanks very much.